it's always a horrendous situation as an attorney or as a person to have that conversation with somebody that comes to my office because their husband or their son or daughter was killed in a worksite accident or any accident for that matter. You really have to do an immediate investigation, regardless of the type of accident, to get all the details. Flush out the details of how the accident occurred, find the witnesses, get the surveillance videos, get the job inspection reports if it was a worksite accident. When a person dies as a result of neglect or the result of an accident, there are different things that you have to be concerned about. The first thing, obviously, is the person who passed away cannot prosecute the case, so somebody has to be appointed to be in charge of that person's estate. When we die, we all have this fictional thing called an estate that handles your assets and your debts. And one of your assets is a potential claim for personal injuries. So the family needs to have somebody appointed. If the person who died had a will, that person will be called an executor. They'll be in the will, and we can get that set up so that they have the legal authority now to prosecute a claim for injuries. If there was no will, the person will be called an administrator, and will also go through the surrogate's court to have that person appointed. Once an executor or an administrator is appointed to the decedent, the dead person's estate, we can then start investigating the case, gathering the medical records, gathering the facts that we need to prosecute the case. Another thing you have to be concerned about is that there is a shorter statute of limitations for what they call a wrongful death claim. There is only a 2-year statute of limitations or deadline instead of a 3-year statute of limitations. And that is something that your attorney must really be focused on, because you don't want to miss that deadline and then forgive the claim. Another issue that comes up, and this is kind of a peculiar aspect of New York law, if the person who dies as a result of the accident dies instantly, he or she will not have a claim for what's called pain and suffering, because you have to have conscious pain and suffering. The person who's injured has to be aware that they were suffering. If they don't have that claim for conscious pain and suffering, the only element of damages that that person or the family will be entitled to is called pecuniary loss, financial loss. So you need to be able to establish that the person was providing a financial benefit to other members of the family. Typically, if he's the breadwinner or she's the breadwinner in a family, earning money to pay for the family, providing benefits to children, providing benefits to parents. There is an element of financial loss just for the loss of services and consortium of a parent to a child, but these are all really detailed elements that your attorney has to focus on, has to hire experts to help prove if there was conscious pain and suffering, to prove the financial loss and what it will be worth to the family. So it's imperative. It's a hard thing to deal with, especially early on after a time of loss, but you really need to speak to somebody early on to protect your family's interests.